A firearms police officer has been removed from all duties after being filmed kicking and stamping on a suspect's head at Manchester Airport. The update from Greater Manchester Police is that they've conducted a thorough review of further information and removed him from all duties. This is the video that lots of people have seen online. It's received a great deal of publicity and I've been tagged many times and asked for my comments. So in this video I thought I would talk about the use of force, when the use of force is justified, and indeed when it can be justified as being necessary, and how it has to be proportionate. And so I will give some views as to what I think about this video, but obviously this video is not intended in any way to affect the ongoing investigation against the officer. This is pure public commentary because it is a matter of public interest. Obviously the video has been blurred out here for the purposes of protecting the identity of both the suspect and the police officer. But you can see from the video here that the suspect is in the prone position, i.e. lying face down on the floor when this happened, but there is, as always, much more to the situation than at first it seems. And so just to be clear about the context and the circumstances for the remainder of this video, these are the following three statements by Greater Manchester Police regarding this incident. First of all, in response to the video circulating online, Greater Manchester Police said, officers were called to reports of an altercation between members of the public at Terminal 2 at Manchester Airport. Whilst attempting to arrest one of the subjects of the earlier altercation, 3 officers were subject to a violent assault, where they were punched to the ground. A female officer suffered a broken nose, and all 3 were taken to hospital for treatment. As the attending officers were firearms officers, there was a clear risk during the assault of their firearms being taken from them. 4 men were arrested at the scene for affray and assault on emergency service workers. We acknowledge the concerns of the conduct within the video, and our Professional Standards Directorate are assessing this. There was then a statement from the Assistant Chief Constable, Wasim Chowdhury, which reads as follows. We know that a film of an incident at Manchester Airport that is circulating widely shows an event that is truly shocking, and that people are rightly extremely concerned about. The use of force in an arrest is an unusual occurrence and one that we understand creates alarm. In advance of what is shown in the footage available, we were called to reports of an assault at Terminal 2, Manchester Airport at 8:25 p.m. on Tuesday, 23rd of July. The alleged suspect was seen on CCTV at a ticket machine in the car park, and officers attended the location to arrest him. During our response, 3 officers were assaulted. 1 female officer suffered a broken nose, and other officers were forced to the ground and suffered injuries which required hospital treatment. 1 male officer has been removed from operational duties, and we are making a voluntary referral of our policing response to the Independent Office of Police Conduct. 2 men have been arrested on suspicion of assault emergency worker, affray, and obstructing police. 2 other men have also been arrested on suspicion of affray and assault of an emergency worker. There was a 3rd statement from Greater Manchester Police that says, following a thorough review of further information that became available in relation to an incident at Manchester Airport on Tuesday evening, Greater Manchester Police has suspended an officer from all duties. A referral has now been made to the IOPC for a full independent investigation. We understand the deep concerns that have been widely raised with us and will continue to meet and discuss these feelings with Greater Manchester residents and elected representatives, whilst this independent investigation takes place. And so with that, in this video, I thought I would do an overall discussion of the use of force as it applies to police officers, and in the event that they are either disciplined or in some serious cases where assault charges can even be brought against police officers. And so as they were firearms officers, and there was a clear risk during the assault of their firearms being taken, obviously that would have escalated the situation quite considerably. And so that, it appears, is the belief that these officers are relying on for their use of force. So let's take a look at the use of force generally. Well, we find that the use of force and its justification in several places, both in legislation and in common law. First of all, we can look generally at the Criminal Law Act of 1967, which provides for the use of force in making an arrest and in the prevention of crime or affecting and assisting in lawful arrest, etc. This says that a person may use such force as is reasonable in the circumstances. And so you're going to hear this a lot throughout this video. Reasonable and in the circumstances. And now, in the circumstances is a subjective test. What did the person think in those circumstances? What did they believe those circumstances to be? So in any investigation, the officers will be questioned as to what they believed was unfolding, and if indeed they believed that this situation was escalating to to the point that they were fearful of their weapons being taken. That's what they might have believed their circumstances to be. And indeed, when I watched some of the video that has been circulating, I did question whether or not one of the suspects was attempting to reach out for that firearm. And if I got that interpretation from watching the video, then it might well be the case that the officers had that belief as well. But obviously, that is not my place to say. That is going to be down to a questioning of the officers. But in any event, Section 3 of the Criminal Law Act 1967 does provide for the use of force. We also find the justification for the use of force in Section 76 of the Criminal Justice and Immigration Act of 2008. Now, the law in this section governs what is reasonable force in the context of criminal proceedings, should any criminal proceedings be brought against somebody for an assault in this situation, because it can amount to assault if the use of force was not lawful. However, the Supreme Court decided that when assessing the use of force in disciplinary proceedings, it would be based on a civil test of the use of force for self-defense and not the criminal test. And I'll explain why that's important and what that is in just a moment. But just first of all, a quick word about one of my partners for my channel. Just a moment aside, if you will, to support a long-term partner for my channel that's really helped me to continue my channel and help it growing and help you to understand law and to keep you safe. Now, since the very early days of this channel, I've helped you to avoid scams and cons, to keep yourself safe, to keep your data safe. And my partner for this video is Incogni, who helps to keep your personal data safe. I use Incogni myself, and what they do is require data brokers to remove your data from their servers. You may not be aware of this, but when you browse on the internet, when you join up with companies, when you buy something and they take your name and your address, your date of birth and all various bits of information, they then very often will sell on that data to other parties. It'll be buried in the small print somewhere to say that they share your data with trusted third parties and so on. And not only do they just share it with third parties, but eventually they end up in the hands of people that are going to sell you as a package onto someone else. And eventually that data can end up in the wrong hands and people can end up taking out loans and contracts in your name and essentially holding you liable for that bill. So one of the ways that I've helped to protect you on this channel is to partner with companies like Incogni, which provides a service which is all done for you when you sign up. And of course, I get you an exclusive discount on this channel. It's a 60% discount off an annual plan. It's linked in the description below with the code BlackBeltBarrister. What you do is you sign up and then they contact these data brokers who initially might be acting perfectly within the law, but they are selling on your data and it gets sold on again and again until people get your data and they use it for nefarious and very nasty purposes. And when they do that, they put you at risk, your data, your whole family at risk. People have had their whole properties end up being in the middle of a transfer that they didn't authorize. They've had loans that they didn't authorize, accounts with mobile phone contracts and various other things that they didn't authorize. All because someone's got hold of their information from third parties, eventually being sold on, and it ends up in the hands of bad actors. So check out Incogni. It is a long-term trusted partner of mine to this channel. They help me to grow my channel and I support them now and again by introducing you to them so they can help you to protect your data. It is a fantastic service. And of course, I get you a 60% discount by being a partner to them for my channel. The link's in the description below. You won't regret the peace of mind, and you will notice a significant drop off in the number of spam emails, spam marketing, spam calls and such like that you get. And of course, the ultimate goal is to prevent people from taking out contracts and loans and such like in your name. So check out Incogni, they're linked in the description below. They're a long-term partner of mine. I've used them for a long time and I wholeheartedly recommend it. If you change your mind, you get a 30-day money-back guarantee, but you'll be happy with the peace of mind for such a small price to pay. So please do check them out. And now let's get back to the video. So back to looking at the use of force and the difference in application between criminal and civil proceedings, i.e. if there were criminal charges brought against an officer for the use of force as against disciplinary proceedings brought against an officer for excessive use of force, one being criminal and one being civil, as per the Supreme Court judgment. And now the difference between the two is also quite helpfully set out by the Supreme Court judgment. At paragraph 31, it says, under the criminal test for self-defense, the first limb or the trigger is assessed on the basis of facts subjectively understood by the individual. What did the individual think? However, if the individual has made a mistake of fact, then the more unreasonable the mistake is, the less likely that it would be that the individual genuinely believed that fact. So it's a sliding scale. So if in a situation such as this, the officer believed mistakenly perhaps that someone was trying to reach for their weapon, then if something like that were a mistake of fact, then the more unreasonable that mistake, the less likely that he genuinely believed it. That would be the case under a criminal test for self-defense. But then we move on to the civil test. So there are still two parts to the test for self-defense under the civil test, but the way that it's addressed is very subtly different. Now, under the civil test, as you can see from paragraph 32, the first limb or the trigger for the use of force in the first place is still addressed on the basis of facts as subjectively understood by the individual. However, under the civil test, so if this were a disciplinary, if an individual made a mistake of fact, he can only rely on that fact as a mistake if the mistake was a reasonable one to have made. So that then shifts the mistake to an objective assessment as to whether a reasonable person would think that that is a reasonable mistake to make. And then moving back to the criminal test to compare the use of force and whether it's reasonable, the second limb, the response, the use of force, under the criminal test, the objective standard of reasonable force is used to assess against the background of the facts as believed by the individual. So an objective, reasonable person, do they believe that the use of force was reasonable in those circumstances that they believe them to be? Under the civil test, very similar but with that qualification, the objective standard of the use of reasonable force is to be assessed against the background of those facts subjectively understood by the individual, subject to that qualification that if there was a mistake, they can only rely on it if it was a reasonable mistake. So what really does all of this mean between the criminal and the civil test, whether there was charges brought for an assault if it was excess force, or whether it's simply disciplinary proceedings? Well, in the case that it's disciplinary proceedings, it would have to be a reasonable mistake. It's not the sliding scale that it would be on the criminal test. This was exactly the situation in this case that came all the way to the Supreme Court in a previous case for the use of force in a disciplinary action against police officers. So how does this apply to all of this situation, and what do I really think about this video? Well, first of all, there is another bit of legislation which is PACE, the Police and Criminal Evidence Act 1984, Section 117, which generally provides police the power to use reasonable force in the exercise of their powers. But now, as I say, moving back to this video, the problem that I can see for this officer, regardless of the situation as it was, is that this individual was prone, i.e. lying on his front on the floor, his rear legs are crossed, his arms are out, and it also appears to me that the officer has his knee on the back of the rib cage here, which is a reasonable way of controlling someone when they're on the ground. But it may still be the case that he believed that either he or another was going to attempt to reach for his firearm, or that risk still existed. But the question still there remains is, if that was a mistake of fact, because that didn't happen, then was that a reasonable mistake to make in the circumstances of disciplinary proceedings, or in the event that something like this turns into a charge for assault against the officer, which is possible if the use of force was deemed unlawful, then the defense of self-defense could still be used. And then that is, does he believe that the use of force is necessary? And that is a subjective test. And then, was the use of force reasonable? And that would be a determination for a jury as to whether or not that use of force was reasonable in those circumstances believed by that officer. And so they would undertake an assessment as to what that officer believed in that situation. And if he believed that, then was the use of force in that situation reasonable given the circumstances? So as you can see, a very different test for criminal charges as against disciplinary procedures. And although disciplinary procedures are a civil matter, the test for self-defense is more difficult, even though it's on a civil balance of probabilities standard of proof. And so I hope you found that a useful overview and some general thoughts about it. There is always a lot more to the situation, and it will really come down to what those officers genuinely believed. Given that they were punched to the ground and a female police officer suffered a broken nose, in all the chaos, they might well have genuinely believed that their firearms were going to be taken. And clearly, as the statements suggest, there was obviously a clear risk of that happening. So it will all come down to what everybody believed and what happens next. And so just to reiterate, those are my general comments, and I am not speculating one way or another whether it was justified or not. That is going to be down to the IOPC and for what happens next. But either way, I hope you found that useful. I hope you found that interesting. Please do subscribe, and I'll see you next time.